Hello, everybody, and welcome to another episode of Compliance Clips. I'm Rick Morgan, and here with my co host John Farquhar, we aim to bring you insights from a diverse range of subject matter experts in the world of transportation. Today, we're diving into a topic that's going to be of great interest to carriers, 3PLs, and logistics providers. Our guest is Heather Devine, a seasoned transportation lawyer currently serving as the in house counsel for TRAFFIX. Heather will be guiding us through the potential pitfalls of a poorly executed carrier confirmation sheet and how it can result in the loss of tens of thousands of dollars, dollars that might be unrecoverable and uninsured. The case at the center of our discussion is Conrad Refrigerated Trucking Inc. versus Atlas Freight. Heather penned an insightful article on this case available on LinkedIn where I stumbled upon it. Stick around until the end, folks. It's another two-part series, but you're not going to want to miss a minute of this. Heather is going to unravel why verbal agreements and carrier confirmations might not offer the protection you think they are. Fail to handle it properly, and you might find yourself not just without a case, but without a legal footing to even file one. So buckle up as we explore the intricacies of the game where knowing the rules is essential. Whether you're a seasoned veteran or just stepping into the industry, this episode is a must watch. So without further ado, let's get into it.
Hey, welcome back to Compliance Clips. We have a very special guest today sitting next to us. Thankfully, not between us, because then that would be the rose between two thorns, and we don't want to have that. We have Heather Devine with TRAFFIX with us. And Heather has a law degree and a background in lawyers, jiggy-miggy stuff. So this is going to be a really fun conversation, what we're going to have. And I'm going to let Rick jump in here because Rick is picking on a specific component of an article that Heather wrote, and we're going to play around with it, and we're going to see what more information we can gather.
Well, welcome, Heather. Before we go into that, maybe we'll just give you an opportunity to give our audience an introduction to you and a little bit about your background and what you do.
Oh, thank you very much. When I heard that I couldn't be the rose between two thorns, I agreed because I thought, John, it's age before beauty. But no. There you go. So a little statement about myself. So first of all, let me say how honored I am to be on Compliance Clips. Thank you so much for taking the time and reaching out to me and expanding my network with you guys now in it. I'm delighted. I have a varied background in terms of education. I have started off with, thought I would go into psychology, and I got a BA honors, and then I moved on to do a Master of Journalism, and I really quite enjoyed it, but I'd always wanted to be a lawyer since I was 16. So I said to my husband, you know what, I know I've done all these degrees and we've paid for it, but I think I want to do one more. And he said, go for it. So then I did my law degree. And I have practiced since 1997 in all the courts, applied to get cases before the Supreme Court of Canada, but not been successful. In about 2008, when I was a partner at Gowling's, a big law firm, I fell in love with transportation. I actually learned to fly. And as I learned to fly, I really wanted to be a commercial pilot, but I'd already established a career and had a team of lawyers I was working on and clients that I loved. So I thought, how can I combine my love of flying with, the law? And I went into looking at cargo, actually, which was a little easier to break into than working for the big airlines like WestJet and Air Canada. But then I really liked air cargo, and my first transportation case was for DHL about some violets, some in vitro violets, and the plaintiff was thinking it was several $100,000 case, and I read the back of the bill of lading and said, doesn't this limitation of liability apply? And they actually called the partner who'd given me the case and said, you've got some dingbat lawyer working for you because this is a $350,000 case, and she says it's $50,000. And moving forward from there, they said, wow, Heather, looks like you can read a contract, so maybe we'll let you do our transportation cases, and grew my own practice. And I really love it. So I've worked for carriers, I've worked for shippers, I've worked for brokers, really enjoy working for brokers because it's complex, the services side. And so that brought me all the way to now being Chief Legal Officer at TRAFFIX.
Well, congratulations on the role at TRAFFIX.
Thank you.
So that is a great segue to this little article that showed up in my LinkedIn feed, which was the reason I reached out for you. And maybe you can tell us a little bit about Conrad Refrigerated Trucking versus Atlas Freight and how every carrier or logistics provider who is subcontracting their transportation needs to be aware of the details of this case.
Well, I thank you, and I agree. When I read this case, because I like to stay current for TRAFFIX, I was really shocked. And I first read a synopsis, and then I pulled the case. And I do encourage, particularly for my colleagues in transportation in Canada and the US, to give it a really careful read. But let me give you a synopsis, as you say. So you've got, I'm just going to use the general terms in our industry. You've got a broker, you got a carrier, and you got a customer. And so the cargo in this case was frozen chicken. And I joke a bit with some of my friends because for a while I had a whole bunch of frozen chicken cases, and I say, not another frozen chicken case, but there's exclusions for frozen chicken under Carmack. But it is important that the cargo here was frozen chicken. So the broker reaches out to the carrier, has an agreement with the shipper. It's gonna ship the frozen, arrange the transportation services for the frozen chicken, and then reaches out to find a carrier to move the load, and has some telephone conversations about the movement of the load. And we can imagine how those conversations would have gone. The details of the case are not that set out, but you just sort of see it'll be when would they move the load, where are they doing the pickup, and the fact that it's frozen chicken, so the load has to be frozen. So there's the back and forth between the broker and the carrier on the phone, and they have a deal. So the carrier says, yep, I'll move that frozen, maybe didn't even know it was frozen chicken, but I'll move that frozen cargo for you on these dates and times in this temperature. And after that deal is done by telephone, the broker sends a carrier confirmation sheet to the carrier, and that's it. But turns out cargo gets lost, stolen, damaged, destroyed. And at that point, the shipper and the broker knew that the shipper had a quota to import frozen chicken. And just because your frozen chicken doesn't end up on people's dinner plates, just because it's destroyed as cargo, you lose your quota. So that value of the loss was higher than you might have expected for the loss of a frozen chicken load. So what became key here was the extra cost of the loss of the quota for frozen chicken, because it meant, of course, the shipper couldn't go and get more frozen chicken to deliver to its own customer. And so it's 40,000 pounds of frozen chicken was coming into Canada. And then what happened is when the shipper, and again, all these details aren't in the case, but you can picture it, the shipper would be saying to the broker, well, hey, I'm your customer. All this frozen chicken is gone. I'm losing my quota. I can't replace it. This is not a $2 per pound loss. This is a loss that includes my lost quota value. And the broker didn't want to lose the customer, so the broker makes a payment to its customer. So as I say in my article, you can make sense. The broker then goes and says, well, I'll pay you, customer. I want to keep you in good standing. I'm going to pay you for the damages, and I'm going to get those damages from the carrier. I mean, they are the ones who had the load destroyed in the first place. But the carrier, quite clever in this case, very astute, said a couple of things that were problematic. They said, well, that was a gratuitous payment you made. You can't sue us for the loss of cargo because we never, and particularly for the damages for this quota issue that you're raising now, because when we agreed to move that frozen cargo load for you, we just agreed to move that frozen cargo load for you. We never agreed to any quota. And the broker would have said, well, wait a minute, we sent you a carrier confirmation form that set out the quota, that made you knew exactly what was going to happen when we sent that to you. You didn't say no, you didn't complain. And the carrier said, aha, well, you have a signature line at the bottom of your carrier confirmation sheet, and we didn't sign it, and we didn't send it back to you. We didn't agree. So the worst case scenario at the end of the day for that poor broker was that the carrier never actually had to step up for the loss of the cargo. The broker took on the loss of the frozen chicken quota. The customer got paid off, so hopefully the customer and broker remained together on that. But the court said, hey, broker, that payment you made to your customer, that was a voluntary payment. So,
wow.
Yeah.
So we've got not just then the loss of the individual shipment, but we've got the loss of their possible future business. And I think this is a very typical transaction from my years in the experience, where you've got the logistics side of either a trucking company or a logistics provider reaching out to a carrier and saying, okay, I've got this load, and we do the back and forth. And okay, carrier, send me your operating authorities, and I'm going to send you the load agreement, and we hang up, and we all think things are hunky-dory.
Exactly.
But what we're saying here is, in this case, the verbal agreement between the two entities did not capture all of the terms that were bound upon the broker. Is that what we're hearing?
That's exactly what you're hearing, that the deal that they reached wasn't subsequently amended properly, or wasn't the full deal.
So essentially the carrier is saying, well, I wasn't made aware of these unique circumstances, so I can't be held accountable for the outcome. Is that kind of a summary?
Rick, you are exactly right. I mean, I always think of contracts as pretty simple. You give an offer, and then there's an acceptance. And so you have to have both. You can have an offer out there that stands, without acceptance. It can be out there for a period of time, but you have to have an offer, and then you have to have acceptance. It has to happen all at the same time. It crystallizes and becomes a contract.
Okay, so that one sounds painful.
Yeah, it is painful.
So in my career, I was both a carrier where I was responsible for accepting loads that were posted, and where we were offering loads to various carriers. And I also worked at a logistics provider where because much like you're doing in TRAFFIX, we were essentially a non-asset provider. We were outsourcing everything that we did. And the challenges we face when we have a larger outsourcing department is you've got more than one obligation depending on who your customer is.
That's
so what is a kind of best practice, or what recommendations would you make for any entity, whether it's a carrier or a logistic provider, to make sure that when they're offering a load, they're transferring the full liability? Are there any best practices that you're implementing at TRAFFIX, or you can suggest for our listeners?
Well, I can certainly suggest what we do at TRAFFIX, but let me. I think it'd be better to go generally into my broad sort of background as counsel for you, because that way then we're not just talking about what TRAFFIX does with its customers.
Absolutely.
Good idea.
So here's the answer I would give you. The very, very most important idea that you want to comply with is you want to have a written contract. That's your most important. You want to have a broker carrier agreement with the carrier, but you want to have a shipper broker agreement. And normally you want to get that first, because the shipper broker agreement by law under the Highway Traffic Act and other laws and regulations, particularly in Ontario, allows you to have a contract for carriage. And that means that you and the shipper reach an agreement. Normally, it's quite lengthy. It tells you which laws apply. It tells you that it's whether it's $2 per pound and provides a very clear process where there's going to be declared excess value. And it also will stipulate, and I think this is very important, that it is the ruling agreement, that it can't be amended by bills of lading and it can't be amended by carrier confirmation forms or anything else except by written agreement between the parties. What this would have done, if I put on my hat as a previous counsel for the shipper, I would have said to the shipper, you got to tell the carriers and make it clear to them up front, every carrier you get, number one, you have to have refrigeration at a certain temperature. And two, if there's a cargo loss, you are losing so much more than just frozen chicken. You are actually losing our quota, which will cause us to have more damages. That's what the shipper should be saying to the broker. And then what would happen is that then the broker in the broker carrier agreement makes sure that it mimics everything that's been said that will be delivered for the arrangement of transportation to its customer. And so it's almost like your first one flows, and starts and flows to you as the broker, and then you pass that along to the carrier. And then I used to make them so they couldn't be amended by any document except on written agreement. So I wouldn't have this issue with the carrier confirmation form or the bill of lading and changes to the arrangement. It would have been set up front. Now, can't do that all the time. Sometimes we work in a very fast-paced environment. So if you're going to use a carrier confirmation form, and I'm sure you've got some other questions for me, I think if you're only using a carrier confirmation sheet, you're going to want to act a little differently. But best case in the wild, wild west of transportation up in Canada is have that agreement.
All right, folks, and with that very interesting commentary on how things need to be done in order to protect yourselves, we're going to call an end to part one of this interview with Heather Devine as we explore the very complicated world that we didn't quite anticipate of carrier confirmations. Be sure to tune in for our next edition because you know what? There's a lot more ground we still covered with Heather. We start talking about certificates of insurance. We start talking about additional liabilities. And we start exploring a variety of the nuances of this particular case, including how it was that the broker in this case wasn't even able to pursue legal recourse to attempt to recover the monies that they paid.